My name is Renard Darrensburg. I am from New Orleans, and I am the judicial administrator of the juvenile court in New Orleans. I can give you what I think is a review of this session. This is a repeat session. I've gotten great reviews on it, so I hear you're in the right session to hear today. Our speakers today are Peter Colson. Peter Colson is a court administrator with one of the largest felony courts in the country. He is a former fellow with the Institute for Court Management and recipient of the ICM President's Award. He is a Award of Merit for Applied Research. He is also a former board member of NACM and has published articles in mental health courts and the Affordable Care Act, as well as in criminal justice reform. He's been with Cook County for 14 years, and he is an avid photographer, though not on this trip. Our other speaker is Ali Abid. He provides research and contributes to advocacy on criminal justice through Chicago Appleseed and Cook County. He is a graduate of John Marshall Law School, where he's the editor of the Law Review. And prior to joining Appleseed, he serves as the Georgia Enlightened Fellow for the study of prisoners' rights, teaching and researching on matters related to criminal justice reform and mass incarceration. So I think we have a great couple of guys here who can give us a lot of information. So with that, we'll get started.
Thank you, Renard. We've got a lot of ground we want to cover, and so we're going to try and be very disciplined with our presentation and move it through. We do have an interactive piece in the middle, so you will have an opportunity to have your input also. Just let me start by saying a year and a half ago, we were invited by the American Bar Association to write a chapter for their upcoming book called The Improvement of the Administration of Justice. Comes out about every 5 or 10 years. So we wrote a chapter on the title of this workshop. The first thing we did when we thought about the chapter was that we thought we should do something fairly strategic, more of a view from 1,000 feet rather than on the ground, and not drill down on everything that's going on in criminal justice. So that's what you will see. So the structure of the workshop is, when I get finished with this brief intro, we're going to team tag on some presentations. Ali's going to talk about how we got to where we are in criminal justice, some of the history of that, looking at mass incarceration and racial disparity. And then I'm going to do a piece on this patchwork quilt of legislation that came up over that 40-year period. And then we're going to break, and we'll come back and look more to the future. What's the new model for criminal justice? So we use the word narrative a lot, and I like it because it's an attempt to tell a story. And so the question we ask, well, what is the story here? What has occurred over the past 40 years that we're trying to tell? So I think this, for us, is the essence of the story, and that is that the United States is on the cusp of significant criminal justice reform, departing from a 40-year history of tough-on-crime legislation in favor of a new criminal justice model based on very different principles. And already we'd want to make a change in this. That was written, I think, when we started the publication. I would take the words "on the cusp of" and I'd change those to "in the midst of," because so much has happened since we started 15 months ago writing this. And I want to tell you what the impetus is, some of which you're already certainly aware of. But why reform right now? A couple of things. One, we do have a growing body of research in community corrections that we didn't have before. We have what I call an evidence-based optimism about what works. We're relying more on evidence, and we're more optimistic. We use social science in many ways much more creatively. There's also, since we're talking a lot about drug crimes, the public's view of addiction, I think, has changed, and it's much more open understanding of what addiction is. And then finally, almost finally, the $50 billion that we spend, and this is really the driver, $50 billion annually on criminal justice with what some would say has a questionable public safety gain. And that's what's driving this. Illinois has a commission. You may have one in your state. Ours is to reduce the prison population by 25% in 10 years. And it's driven by a state budget that's broke, and hopefully also by a more enlightened view of incarceration and what we should be doing. So I'm just going to share 3 quotes. It's other people speaking about the narrative. The first is from a judge from New York. For too long, many judges have been too quiet about an evil of which we have been a part, mass incarceration of people in the United States today. And I'll just throw the challenge out to you. If we convert that to our profession, where have we been with this subject, and where are we going? Obviously, this week, there's a lot of discussion about this subject here. The next is from the Supreme Court, Justice Anthony Kennedy. If we look closely at America's prisons, we should be startled by what we see. Our resources are misspent, our punishments too severe, and by that he means often too long, and our sentences too long. And the third quote is the most provocative and challenging of them. It's from a legal scholar from Stanford who wrote a book called The New Jim Crow. And Michelle Alexander says, quite belatedly, this came to her later in her career as an attorney, I came to see that mass incarceration in the U.S. had in fact emerged as a stunningly comprehensive and well-disguised system of racialized social control that functions in a manner strikingly similar to Jim Crow. Now that's a provocative statement. I've read much of her book. To me, she makes a pretty compelling argument and well-researched and well-written, but I invite you to pick her book up and make your own judgments about that. Ali?
So let's see here. So I'll be talking about mass incarceration and increasing racial disparity. So much of the purpose of this setup is that we'll have a discussion amongst you all as the centerpiece of this presentation. So a lot of the facts that I'm going to be running through, particularly statistical points, is stuff that many of you will already be familiar with, but I'm just laying the groundwork again, so we're all starting from roughly the same basis. So with regards to mass incarceration, we've often been told how out of step the United States is with respect to the size of our incarcerated population, particularly with respect to the number of people behind bars. One thing I wanted to draw attention to is the size of our correctional population as a whole, in addition to just the jail and prison population, but also the probation population has expanded so greatly over the last 40 years as well. So right now, as of year-end 2013, we had approximately 7 million adult Americans under criminal supervision. And that total correctional population was 1.8 million in 1980. So prison populations have quintupled. Probation populations, which are often overlooked as being the largest group, have quadrupled. And that's sort of demonstrated by this next chart. If you can see up there, that top bar is the probation population. People who are under a form of corrections that we often don't talk about because we often have held that up as a form of progress, that look, these people are not behind bars. But this should be taken into account as well as we talk about the sheer size and scope of our correctional population. It's interesting to note that all of these, or nearly all of these, have peaked. The probation population has peaked around, in this data table, like has peaked around 2005 with nearly 4.2 million people under probation, and the prison population peaked in 2010, 1.6 individuals in prison. Same with the jail population. Moving beyond that, one of the other major changes that we often talk about is, with respect to the war on drugs, is just how much drug crime has changed in the way it is prosecuted. One particular nuance I wanted to draw attention to is that most of the changes occurred not in a targeting of drug sale and manufacture and trafficking, but on drug possession in particular. The arrests for drug sale and manufacture have remained constant from 1987 to present, despite an increasing population. So with taking that account, they've actually dipped slightly. However, arrests for drug possession have tripled. One of the key features of that, of course, is the racial disparity that's present. So, and now all the previous numbers I've provided, these are all from the Bureau of Justice Statistics. With respect to racial disparity, the data I'm using right now is from the Substance Abuse and Mental Health Services 2011 survey and study. It found, confirming many other large studies that have been done, that the rates of use across races for heroin, crack, and marijuana are largely identical. The only place in which there is a substantial difference between use of drugs across races is the fact that the white American population uses powder cocaine at a higher rate than black Americans. 17.1% of the white population has used powder cocaine versus 9.9% of the black population. Despite all this, black Americans are arrested for drug possession more than 3 times as often as whites, and serving in the state prison system, of the 225,000 individuals serving for drug offenses, 45% are black versus 30% being white. Now, in terms of other landmark reports, the Pew Center's 1 in 100 report from 2008 that was put out analyzing the prison population as well. The 1 in 100 name, of course, came from, that was the point in the prison population growth and the jail population growth where 1 in 100 American adults were behind bars. When you break that down by race, it was 1 in 15 black men, 1 in 36 Latino men, and 1 in 106 white men. With women, though they're incarcerated at a far smaller extent than men, the racial disparities were also present. 1 in 355 white women versus between the ages of 35 and 39 were behind bars versus 1 in 100 black women. The U.S. Sentencing Commission in 2013 conducted a study of the federal prison system and found a federal court system and found that black offenders received sentences that were 10% longer than white offenders. Now, that study controlled not only for criminal history, but also for the severity of the particular offense and also the sentencing tendencies of each individual district. Taking all that into account and controlling for all of that, black offenders still received 10% longer sentences. Yes? Yes. Across the board. So basically comparing, a black man and a white man with the exact same criminal history, exact same severity of the particular offense before them in the exact same district. The black individual would still receive 10% of a longer sentence. Moving out of the federal system, looking at the whole state and federal system, African Americans are 21% more likely to receive mandatory minimums sentences overall, and 20% more likely to be sentenced to prison. So this is, again, just a review. Many of you are already familiar with all the particular statistics and such, but just in order to set up our discussion, which we'll be transitioning to in just a minute or so.
That's a good point. Every time I presented this manuscript to our felony judges, we have 45 felony judges in our courthouse, I got that question, well, what about criminal history? Does it control for criminal history? And I think it's really critical to realize that these studies do take that in consideration. It makes it more striking in a way to see the data. The other thing is to keep in mind as we talk about, I'm sorry.
I'm going to bring you, I think because we're live streaming, we have to be on the microphone when we have to, so I'll just walk over to you.
Oh, I think that might be for you.
The question that I have is on the first bullet, when it says that 21% are more likely to receive a mandatory minimum. Mandatory minimum is a mandatory minimum. I didn't think that was racially motivated.
Right. So that one is not part of the U.S. Sentencing Commission study, which was comparing across the. So that's just overall. African Americans are more likely to be charged with a crime that would have a mandatory minimum. So that's a separate study. So the U.S. Sentencing Commission was doing that apples to apples study. That first 2 bullet points relate to a sort of broad overview of both the state and federal system. Who's serving mandatory minimum sentences? African Americans are 21% more likely to be serving those. So, right.
Thank you. Our introducer mentioned I was a photographer. There's a Chicago cop who has produced a couple books, and he goes into the jails and the hospitals and does some remarkable photography of what you wouldn't think is a beautiful place, but he has a pretty good eye, including our lockup. Things to consider in this discussion are the sociology of how drugs are distributed when we start talking about these inequities. And in particular, the fact that in the African American community, drugs are often distributed in the kind of an open air market. And in the white community, which Ali has shown the data about, I think it's much more hidden. It's not out in the open in that way. Very often it's delivered. So we have 2 different events going on here. So just a word about the sentencing, this patch quilt of sentencing that started with the Rockefeller drug laws in 1973, which they then in 1969, almost 50 years later, turned over. And what we found in this legislation where if you boil it down, it gets pretty complex because each state can be different in their combination of truth in sentencing laws and mandatory minimums, and you have to look at the collection of state laws. But we found an increased harshness of penalties for criminal behavior over that 40-year period. Harshness, you can change that to length of sentence. Primarily, that's what that relates to. A growth in mandatory minimums, and the key here is the discretion is taken out of the judge's hands and required to sentence according to the mandatory minimum. Over and over again with our judges, we met with our governor's key person on safety, and our judges said, look, do away with these mandatory minimums. Let us decide what we're capable of doing. Give us some discretion. Let us make a difference in our ruling depending on the circumstances, and they're not able to do that in many instances. And then finally, there's this, what I call a pernicious multiplier effect that we've encased in this 40 years of legislation. And because of truth in sentencing, you do the time that says you're going to do. A person can enter, and particularly habitual criminals who come back a second and third time and keep in mind that drug use is about addiction, and it's about relapse and coming back from relapse. So the habitual nature is almost built into that kind of a system. So they did a meta-analysis 2 years ago, the National Research Council, and they said, well, you know, in the end, what caused that great increase? And these changes in punishment policy were the main and proximate drivers of the growth in incarceration. Prison time was significantly required for lesser offenses, so we are upping the ante. Time served significantly increased for violent crimes and for repeat offenders. Drug crimes, particularly street-level dealing in urban areas, became more severely policed and punished. So it begins to answer the narrative, at least in our minds, of what was going on with this legislation and what some of the problems are with it. Yeah.
So now we wanted to open it up into a form of group discussion, specifically focused on your roles as court administrators and court managers. I'm going to put up some group questions for you guys to discuss, but what I would suggest is if everyone could either pair off or form small groups to have these discussions about the questions we'll put up, and then in about 10 minutes time, I'll pick out certain groups to sort of report out as to what you discussed. So the questions are, what should be the role of court administrators in addressing issues of mass incarceration and racial disparities? What obstacles stand in the way of court administrators addressing these issues? And what might be the features of a new criminal justice system designed to address decarceration and racial disparities head on? So if you would all just turn to your people right next to you. Yes, there's a question.
Just can you define decarceration?
Decarceration, literally opposite of incarceration. Just acknowledge, designing a system perhaps that acknowledges that there are too many people heading in to the community corrections system right now. Yeah.
We've done better on time.
Yeah. May have missed a few ideas here and there, but we'll fill it in as we go along. Okay, so it's 22.
Yeah. So we'll give them. We can give them
About 8 minutes or so.
Yeah. We'll see. We'll see in like 7, 8 minutes if
What time do we go?
conversation is
3:15.
We've given 15 minutes for the whole.
Yeah.
So, right.
We'll be way ahead.
You've written this out. You've written this out.
That was me. That's what I just did.
Yeah, I know, but then the exercise.
Oh, I missed 10 minutes. Okay, so it's really 2:40.
So
that's all right. I'll give us more.
We'll give us more time.
Because I got stuff on the we may not then.
I mean, here, I'll probably say, I might wind up sticking over also.
Well, what do you mean by?
I mean, just, I think it's good that we have this.
Oh, yeah.
So give yourselves about a minute, and then we'll be reconvening.
Some of these groups are going to report out, so.
Yeah.
Okay. So what I'll do is I'll just point to a group of you all and just to ask what was some of the major takeaways from your discussion. Let's see here. I'll start. How about this larger group over there?
Well, we didn't really come to, we didn't answer any of these questions. We just talked a lot about what we would start to do. And in Delaware, one of the things that we are doing is we are doing a study that actually the results should come out in August of racial disparities in the system from the time of arrest, so it doesn't take it before arrest, through disposition. And the initial results seem to show that the disparities happen based, because it was a regression analysis when you look at criminal history. So criminal history is really driving it. And criminal history, as I was talking to this gentleman who works in the juvenile system, seemingly driven from juvenile records. So we're sort of starting to think about what the focus should be in terms of our looking more. The long story short, we need to know more. But we're at least starting to look to see what the issues are, because it doesn't look like, at least right now, that apples to apples, just like charges, taking out criminal history, that there's much of a disparity, but that the history really factors in. So we're looking at things like bail reform, pretrial detention reform, which reduces time in the system even by a couple of days can have impact. So we're starting to look at things like that.
So you're starting to measure things.
Yeah, exactly.
And also to add to her point, as a clerk court or judge of probate, as when the issue or charge is filed, then that starts a criminal history. And so it appeared that the key is charge in order not to get to the mass incarceration. If we would look at addressing the issue of what is really the issue before a charge get there, if it's substance abuse treatment that needs to be done or mental health issues that need to be done before we start a criminal history. Because once, in the state of North Carolina is where I'm from, once the person is charged, then that criminal history starts. But if we start addressing the issue before the charge, that may kick back some of the mass incarceration, get that person treatment, rehab, and not a sentence in jail where already mass incarceration, and we're not addressing the mental health and the substance abuse. But once they're charged, let's begin to compound the issue, and we're not addressing the treatment.
So it's front end.
Front end.
Well, that's really fascinating.
Let me just add, in Cook County, 22,000 felonies a year. About a third of them wash out. We get 22,000, but they start out at 30 some stuff. About a third wash out, like arrest and filing. So there's a lot of leeway there for things to happen.
Get into another one of the expunction. That's a
clear, when you talk about that washout rate, are you talking about a state where you use predominantly file by information or a grand jury? What's your main method? Wait, what's your main method in that state? Is it initiating criminal? Is it an information file or is it grand jury?
50% of our felonies come through information and about 50% through grand jury.
So are most of the washouts on the ones that are by information?
They are.
Yeah.
Okay.
That's a good point. Good point. Very good point.
So actually, just sticking with that group, well, your discussion regarding these questions, your role as court administrators in tackling these problems.
Well, we never got to number 3, so I'll put that right on the table.
That's fine.
I think in number 1, I think in many ways we were similar to the response to the prior group. You know, we talked about trying to do things like I think providing good data to the judges and being able to communicate that. I think it's making sure we have some level of credibility with the bench to be able to bring things forward. I think one of the things we don't rely upon is the bully pulpit of the presiding judge. That's the person who tends to have the largest moral authority in the criminal justice task force. And you can bring those people, they can bring the other partners to the table on some of these issues. And my colleague here from Scotland talked about trying to help with data to develop a greater situational awareness among the judicial officers of all the things that are actually going on in the system that may not be apparent by just looking at one case at a time. So judges, are kind of trained that way. Look at one thing instead of looking at a lot of things.
Certainly.
I'm trying to think. I guess one was the obstacles. I think one of the biggest obstacles I think we talked about was the prosecutor. The prosecutor frequently drives the train. They drive the charging decisions, who to charge, and what cases are the cases du jour. And I think that can be an enormous challenge for court administrators or anybody else to address. So I think that's about as far as we got. Go ahead.
Yeah, thank you. Just to add a few things on, maybe picking up on point 3, with a view from how the system operates in Scotland just now. It's been absolutely fascinating to hear some of these discussions, and the approach we have is actually quite different. I look at some of this, and some of the things I hear being discussed are things that we actually have running in our system. I also hear some great ideas that I want to take back, but certainly just now in Scotland we use alternatives to prosecution quite heavily, both financial and non-financial references to training, to drug and alcohol referrals and so on, before someone reaches the court system. They would then graduate through the court system if they were still being rather naughty, at that point, if they were convicted of something relatively minor, there are statutory presumptions against short sentences. So even if a judge were minded to impose a 6-month sentence, that will be commuted automatically to a community alternative. If you were a little bit more naughty, or really quite cheeky, as we might say in Scotland, you may get something between 2 and 5 years, at which point you're entitled on good behaviour in prison to automatic release at 50% of the time served in the sentence. If you were really, really naughty and got something worse than that, then you're in jail and you're being kept there. But that comes from a lot of analysis that we conducted that says when you look at the purposes of punishment, if you look at retribution, public perception, public protection, rehabilitation, reconciliation, and overall societal benefit, all the things you look at as the things that a good penal system should provide. The evidence that the research we've carried out suggests that incarceration is only effective for 2 of those, for retribution and for public protection for those who are assessed as a danger. Community-based disposals are more effective and have been proven to be more effective for rehabilitation, for reconciliation, and for societal benefit. So if you don't need the public protection and you've had the retribution, then you really need to be looking at those alternatives, or else you're wasting money and you're wasting opportunity of your people as well.
Yeah.
That's an excellent point. I just wanted to say in Illinois we have a SPAC, Sentencing Policy Advisory Committee. And those questions have to be raised about how effective is incarceration, how effective is long periods of incarceration.
This is an agency which, whenever a bill addressing changing a sentence is put forward before the legislature, they automatically perform analysis about the fiscal impact and other impacts of the sentencing change, which I know is duplicative of something that happens in other states as well, similar agencies now that are operating. Yeah.
So you're right. For example, 1 out of 9 people in prison today in the U.S. are there for life. And now that we've followed these long sentences, which have become more and more severe, we're getting what I call virtual life. 35-year-old who gets a 40-year sentence, those harsh sentences they were talking about, because he's doubled down as he's gone through the system, and so now we have this aging population. It's a real issue.
So just as a no, actually, go right ahead.
So I'm going to call on my colleagues here, but we talked about a couple of different things. We didn't get through all of the questions either. But you know, the first conversation that we started with was the notion of implicit bias. We've been talking about that quite often during the course of this conference. We talked about it from the standpoint of general bias, but also with the judges. But one of the things we thought as court administrators we can extend it to is actually staff that are managing and supervising defendants. Quite often we have pretrial programs or probation under our helm, and I think it would be neglectful not to assume that implicit bias exists there too. And so for the people who are working for us, who are tasked with supervising people, they're going to be the first line of defense if you're talking about folks who are going to be making recommendations to the judge as to whether a person should go to prison or not for violation of probation or whatever the case may be. But so extending it out to them, and I think they're doing some unique things in Ohio, which I'll let my colleague talk about. The other thing is providing data to judges. I think we've heard that a couple times. And for a court administrator, the obstacle is that if the judges are not ready to see the data, you are going to be placed in a very awkward position. And so I think the obstacle is walking the fine line between providing good data and not being seen as an advocate for something different with the judges. And so
right, that fear of putting data before a judge and being not only is the response, oh, I'm not interested in this, but also like, why were you looking at this?
Exactly. Exactly. We talked about one of the things I mentioned was just having the ability to work with your colleagues to figure out what you haven't done yet. But I think, you know, in creating new programs, we know, you know, we see this all the time. We talked about people who are coming through the system and then you don't have access to jobs and you don't have access to housing. But even if after you create those instances, you have to have people who are willing to use them. And so, you know, trying to make sure the word is out when you have innovative programs that may help with, you know, folks that are coming through the system so that they're not back on the street and you know, kind of being subjected to this again. And then lastly, I was thinking, when you were talking about, Peter, multipliers, right? One of the things I saw as a multiplier very recently was the case out of Utah where the Supreme Court actually made a decision that impacted search and seizure, if you remember. And when you talk about multipliers, you have the legislative standpoint. But what happens when you have judicial decisions that change the landscape of, you know, in minority communities where people are, in some instances, well, based on your data, targeted in a way. And so when you have not only legislation, you know, the strict legislation, but then you have cases coming out of the Supreme Court like that one that suggests that there is going to be even more flexibility to placing people in disadvantaged communities in jail. I sometimes struggle with this. So if we're talking about how to decarcerate? If you're talking about how to decarcerate people, but we have rulings coming out that seem to support incarceration, how do you push that information out to your judges and people who are in the system so that it can respond appropriately?
Yeah, that's a good point. And safe incarceration is a term that's being used.
Decarceration.
I went to a 3-day conference in St. Louis, and
I was just going to make add a couple points to what was said. In our jurisdiction, related to this, the expungement issue, we have a community outreach effort that was motivated by one of our judges, where I think we're doing about 8 workshops throughout the county on different weekends primarily, to make people aware and educate. And also the public defender and the Legal Aid Society are partnering with that, so that people can be made aware of what qualifies under Ohio law, and give them the resources and the information and assistance from the legal side to facilitate that. Also, I would join in with what the gentleman over here said in that group about the prosecutor driving a lot of this. I mean, a lot of times you're constrained by what you get out of the grand jury, which is driven by the prosecutor. And one of the things that we've talked about in our court is the number of cases they come out indicted as felony 1s or 2s, and if they end up at misdemeanors, there's something wrong. And it touches one of the prime topics now under consideration in Cuyahoga County, kind of driven by our local newspaper, is bail reform, and comparing us to other jurisdictions. And one of the things they've focused on the courts, and one of the messages that we're trying to get out is, we're part of it, but so is the prosecutor. You need to focus on what they're doing, because it all works together and has an impact on what ends up in the court and how that case is resolved.
And one of the issues there, as ever, is this is an independently elected official. This is, it doesn't follow the same hierarchy that the court administrator falls under. It seems like a lot of what, and from our session yesterday, on the same session, a lot of what people were pointing to as a useful tool, something that would get over the one of the major obstacles is why we would be in a position to hand out data, or to put it, is having it be required. If you guys could point to something that said, I'm required to collect and report on this data, then that becomes a lot easier to navigate the particular relationships.
One thing we also brought up, but it's kind of like a little bit of a core for me, is people who have been basically convicted first-time felons, and they did their sentence, they did their probation, yet they had this black stain on them that they can't escape from. The felony, getting good jobs or getting housing, like we were talking about. And I didn't know if there was anything out there that is basically saying, we can develop a point system or some type of system to where they stay in good contact, everything's fine for a course of time, non-violent offense, not the violent stuff. But even that, I know many people who've had drug convictions. One woman that I knew was convicted in shoplifting, and I had to get rid of her because I was an administrator in a teacher setting. She was 17 years old, 36 years old, 17 years later. That crime is still following her, rather than getting it, either expunged or locked away, basically. So that's what we came up with.
Yeah, no, and that's a major issue, and a major area of reform and proliferation of programs, deferred prosecution programs, to try to deal with that. So, just to carry on with our. It's a good segue to the next bit, and then we'll be opening it back up to questions right at the end. We wanted to go over just certain things that are happening right now, and by right now, anywhere in the last 10 to 15 years, as elements of reform building our pathway forward. So I was going to talk about diversion, and Peter was going to talk about community reinvestment, the new model of criminal justice. So in terms of diversion, again, this is stuff that many of you are familiar with and is happening in your courthouses, in your districts already. Various forms of diversion have taken over, from pre-plea programs like deferred prosecution programs, where the incentive is that charges are dropped or withdrawn at the end of them, to post-plea programs that are structured forms of probation, or specialty courts such as drug courts, which is the most established model of an alternative court going back to 1989 now. And in addition to those, new things have come up. Community courts, from the Red Hook Community Court in Brooklyn, and then throughout the country now, with many different sites being discussed, and BJA talking about the 10 new community court projects that they've been funding, where courts take place in the community and often take advantage of different forms of mediation and restorative justice processes to deal with offenses being done. So I wanted to talk a bit about sort of like one of the underlying frameworks of when we talk about alternatives, alternative prosecution and alternative sentencing, which is the risk needs responsivity framework. I'm going to put this up here. So often rooted in the drug court research of the last 3 decades and expanding outward to other forms of programming. Risk needs responsivity, also oftentimes a really related concept is sequential intercept, which you may be familiar with, is the idea that one size does not fit all, that particular offenders respond better to particular levels of criminal justice intervention based on their risk levels and their need levels. Now, what risk level means in this context is not risk of violence or risk of anything in particular, but simply the risk of reoffending, getting re-involved in the criminal justice system, if that's high or low for an individual. And the need level, we're talking about particular factors that can be changed about an individual's circumstances that relate to criminogenic risk. So that could be substance dependence, mental health issues, education, employment, associates and peers and living situation. So, so basically you have 4 quadrants that open up, and an individual who's appropriate for one quadrant will likely suffer worse results if they're misplaced in it. So, for example, if you were dealing with an individual who's high risk of reoffending, re-involved, and high need, a serious persistent mental health issue, a drug dependence issue, then that person, the quadrant, the programs that fit in that quadrant are your specialty courts. A low risk, low need individual who is running across the criminal justice system, sort of a happenstance in their life, sort of a slip off from what would their usual setup in their life would be. If they must be involved in the criminal justice system at all, a dismissal, and they're not dismissed or nollie-pros, then the best thing for them, and anything else would be worse, is probably a deferred prosecution program, where there may a light level of criminal supervision, court supervision, and their charges are dropped. For your high risk level individuals who are quite likely to reoffend but low need, they do have some drug abuse but not drug dependent. They're mostly, the idea is that they will not comply. Then what these individuals usually need is a swift, fair, sanction-based probation program mixed with cognitive behavioral therapy, and that's it. Now, and then for the sort of stranger situation of high need but low risk individuals who run into the program, there aren't very many articulated programs for this, but basically some level of light supervision probation paired with a lot of treatment opportunities. Now, this is all backed up with drug court data and such as that, but this underlying framework is taking over more and more how court systems and courthouses divide up who goes into what program is all, but oftentimes not in a very centralized way. And so I just want to throw that up there as something to discuss or have on mind. Peter.
So we've got about 4 or 5 minutes left. The last words are about community and the importance, if we're going to solve this problem of mass incarceration. And one question is, how do you know when it's mass incarceration? And the 2 tests I use are compare us to other countries and look at our history. Where were we 40 years ago? And we see this remarkable increase, 4 or 5-fold. So 27 states, let me just look here for a minute. Before I say that, so this Eric Kadur is a researcher in New York. He went into Rikers Island and he said, give me all your addresses, everybody that was incarcerated in Rikers Island in 2014. He found their addresses and he went into New York City and he found what he called were $1 million blocks. Blocks where the state of New York was spending more than $1 million in incarceration costs. and government programs on that block. And a rather remarkable thing. So in cities like Chicago and Milwaukee and New York, those are three I'm aware of, where you have de facto housing segregation by race, you begin to see these the devastation in communities on this kind of mass incarceration. Children's uncles and fathers and brother and cousin and next door neighbor begin to join this this felony world, and the whole neighborhood becomes really, really demoralized and devastated in many ways. You don't feel that in every city in the country, but in our kind of city, it's very obvious. So just a last word, woman from North Carolina, we did set up the Justice Reinvestment Act, and a number of states, North Carolina one, started taking money and putting it back into the community. They found mixed results. Some worked, but the missing, as they did their first analysis of community reinvestment, they found one thing was missing, number 3 there, an organized coalition of city and county officials, grassroots leaders, residents, and service providers really coming together around this. How do we rebuild the community? How do we get involved in this? So we come, the last question is, well, what would this new model look like? And I guess what we reckon, we would suggest a few things and ask you if you want to add anything. Evidence-based public policy, using data properly, eliminate mandatory minimums. Judges saying, hey, you got to take away that bottom and give me some discretion. Addressing racial disparity head-on. Eliminate mandatory minimums. Evidence-based public policy. Ali, you want to do the last 3 or 4?
Yeah, and making clear in your system, and this is more of work for the legislature, but also in terms of courthouse culture, that incarceration is no longer the default option. Right now, we talk about diversion. Everything we do, aside from incarcerating people, we call diversion, which creates this bizarre assumption that prison is where people are supposed to be going. Smart decarceration. So the idea of making decarceration an explicit goal of your system, and so you can plan for it in a way that is intelligent, that accounts for public safety, that brings stakeholders together. Another, of course, that we discussed was community reinvestment, and that's part of smart decarceration, and really the cornerstone of all of this is the fact that investing in the communities that are affected and often policed the most in other ways aside from that, and not being afraid to innovate. And if there was anything more you wanted
Yeah, and this notion of innovation, we do have to experiment and fail. We're trying to build a new model. We don't know yet all the pieces, and innovation, testing, trying things is going to be really critical. But let's just end with what would you like to add as we think about a new model? Yes.
I think this is kind of speaking to what you were worried about earlier in terms of testing. Okay. In terms of judicial discretion, you can have the problem in both directions. Is it working? Oh, it is working. Okay. I'm usually pretty good with a mic. In terms of judicial discretion, you can have the problem in both directions, and I think you were trying to suggest that if we give more judicial discretion, we can potentially have greater problems. It might not resolve the issue, and so I guess in short, what I would suggest is that where incarceration is appropriate, we need to take a look at the maximum penalty or the maximum term of incarceration for various offenses.
That's a dialogue we had in Illinois, and one of the questions came up was, is anything accomplished, looking at the values that gentleman talked about, is anything accomplished when someone's incarcerated more than 20 years? Good question. When does the payback start diminishing? You know, do we want to produce prisons with elderly people growing up and spending their entire lives there? And you have to be discreet. It's not for everybody. So we had a gentleman who did his time. He was 75. He was in dementia. He had no place to go. And the head of the State Department of Corrections admitted off the cuff that they had taken him. They had no other alternative. They take him and they went into the city and they found a medical center, hoping that the medical center would pick him up and find some place for him to go. So it's, and just one last point I'd like to make. It is a choice. If you don't give judges discretion, we know what the charters look like. If you give them discretion, yes, you now you got other things. You got education you have to do, but you know, you got to decide which system works for you. Does that speak to your question? Okay.
So unfortunately, we are now a couple minutes over time. If anyone wanted to stay behind to talk Q&A with us, that would be very welcome. But of course, you know, there's a big conference going on, so